All right, what do we want to say about Nevada's judicial system? In some ways, right, similar to the federal system, in some ways quite different. Way in which it's similar, right, is that we have a sort of a three-part system here, levels. We have at the top the Nevada Supreme Court, a seven-member high court. We have the Nevada Court of Appeals, a three-member body, and we have the district trial courts, right? Just like at the federal level, we have the U.S. Supreme Court, the various courts of appeals, the district trial courts, not so different at the state level here in Nevada. What's different? There's a lot of differences, right? One would be, right, that we elect our judges and justices, 6-year terms, nonpartisan. Obviously, at the federal level, that's not how it's done at all. There's a lot of important sort of pros and cons to having elected state judges and justices. On the one hand, right, it keeps judges and justices accountable to we the people, something that we want in a democracy, perhaps. Uh, and the evidence, I would say, is that if you compare our approach, which is the most common among all the states, right, our elected judges and justices, we're right in the middle, we're in the mainstream. But there are some who do more of a what's called a merit system. Maybe the governor chooses with some input from the legislature, uh, various forms of that. There's no evidence that that produces better judges and justices than elections, right? So if that's the bottom line analysis, you might say, hey, elections are imperfect, but apparently in terms of the quality of who you get on the bench, about the same as other non-elected systems. Now, the critiques, right, would be oftentimes, right, we the people don't have a lot of information about these judicial candidates. Because it's nonpartisan, we don't have a party label to help us decide who to vote for. Are judges and justices really nonpartisan? Not really. So we're denied, right, we the people, an important piece of information. And judicial candidates are often limited in what they can say during an election campaign. They can't talk about particular cases that might come before them in the future. There's a lot of things they're not allowed to talk about under judicial codes of conduct issued by the State Bar of Nevada. So they often say, right, very vague things that don't really tell us much. I'll be fair. I'll be balanced. I'll make sure that the law is enforced fairly. I mean, everybody says that. So it can be really hard to know who to vote for. And you take away those partisan labels and you've lost key information. That's a critique of our elections. I would like to see them, if we're going to have them, I'm old school, I'm from Pennsylvania, make it partisan. Make the candidates either Democrat or Republican so you kind of know what you're voting for. That's at least one piece of information that helps. And it matters to what courts do. It just does. In some fantasy land, I guess it doesn't, but in the real world, it can matter in some cases. And also, right, the issue of money. Who contributes to judicial campaigns? Mostly law firms and corporations and businesses who have skin in the game, who might come before that judge in the future. At the very least, as they say, it creates the appearance of impropriety, if not necessarily the substance of impropriety. Gives we the people maybe less confidence in our courts, shaped by big money. I would say that has been a real problem in many states. It's gotten fairly corrupt in many ways, huge money going into some of these races. In Nevada, I think we've mostly steered clear of that. We don't have a ton of money in our judicial elections. Our courts are not, our Nevada Supreme Court is not deeply partisan. Our Court of Appeals is not deeply partisan. We haven't had that polarization that we've seen in so many states, like Wisconsin. Take a look at that. Google that stuff there. The Wisconsin Supreme Court is intensely partisan, intensely ideological, involved in all sorts of controversial hot button issues where the only thing that seems to matter is, are you a Democrat or a Republican? We don't really have that here in Nevada. And interestingly enough, right, like Wisconsin, we're a 50-50 state. So apparently there's two ways to be 50-50. 50-50 and you're at each other's throats, and 50-50, we mostly get along here in Nevada, certainly on our courts. That's I think worth mentioning. But these are serious critiques, right, of state judicial elections. And then one other twist I would mention here very quickly: 6-year terms. At the lower levels, the district trial courts, it's not uncommon at all for a judge to leave the bench before the end of their 6-year term. How do you replace that sort of early departure? Turns out it's unilateral gubernatorial appointment, right? Named by the governor. I'm not even critiquing that necessarily. I'm just pointing it out. It's done by the governor. The governor gets to put onto these open seats whoever he or she wants. And then that individual named to that position has to run again in the next election cycle as quickly as possible. Typically, the incumbent wins. We should also say that. Much as with Congress, judicial incumbents typically get reelected if they choose to run for reelection. So in other words, right, gubernatorial appointment plays a real role in who gets onto the district trial courts. And then they typically get elected at their next election cycle. So that gives the governor, right, a little extra influence over who sits on our trial courts. Not just elections, but also some element of gubernatorial appointment. And in the Court of Appeals and the Supreme Court, we have an interesting system there. It's a little in the weeds. I don't want to make it seem like it's law school or anything, but it is an unusual approach. I think only 2 or 3 other states do it this way. You know how at the federal level, right? If you want to work your way up to the Supreme Court, you got to start at the federal trial courts, right? If you lose there, you can appeal to the Court of Appeals. If you lose there, you can appeal to the U.S. Supreme Court. That's not how we do it here in Nevada. If you lose at the trial level, the district court level, you appeal it to the to the Nevada Supreme Court, right? And they hear about 300 cases a year. That's too many, right? That's why it was about 10 years ago, we the people voted at the ballot box to create an intermediate Nevada Court of Appeals to handle the damn caseload, because 300 cases for 7 justices was too many. So, and then they have to take all the appeals, right? At the federal level, the Supreme Court takes almost no appeals. They get what, 7,000 petitions a year, and they hear about 100 tops, maybe, right? They have discretion to reject almost every single case. The Nevada Supreme Court does not have that discretion. They must take all appeals, mandatory. So they were taking 300 cases a year. That was not sustainable. So we created a Court of Appeals to help with the workload. So if you lose at the trial court level, you still appeal it to the Nevada Supreme Court, and then the ones they don't want to hear, they kick down to the Court of Appeals. About half of them get kicked down to the Court of Appeals. The Nevada Supreme Court takes the ones that they think are more interesting, more important. Now, it's also true, though, that if you're one of those parties to a case and your case gets kicked down to the Court of Appeals and you lose at that level, you can then appeal it to the Nevada Supreme Court, and they have to take that appeal. So it's a somewhat convoluted, somewhat unusual system that we have here. All right, thanks.